Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. A Delhi court today continued hearing the application filed by Delhi Chief Minister Arvind Kejriwal for administering insulin to him in jail and allowing consultation with his doctors through VC. The Chief Minister has stated that since his judicial custody, his blood sugar levels are fluctuating at an alarming rate due to acute diabetes, which is posing high risk to his health. During yesterday's hearing, the Enforcement Directorate had alleged that Kejriwal was eating mangoes and consuming tea with sugar in it, while claiming an increase in his sugar levels in order to create a ground for bail. Today, Kejriwal's counsel, Senior Advocate Abhishek Manu Singhvi, told the Special Judge Kaveri Baveja of Rouse Avenue Courts that the mangoes had been made to look like sugar bullets by the Enforcement Directorate. He clarified that Kejriwal used sugar-free in his tea. Senior Advocate Ramesh Gupta, also appearing for Kejriwal, objected to ED's presence and said that the Central Probe Agency had no role to play in this matter as the issue was between the Chief Minister and the jail authorities. Special Counsel for ED, Zohaib Hussain, replied to this by saying that the very fact that allegations of malafide had been made in the application, it made the probe agency a party. He added that the Chief Minister was prescribed a very regulated and restricted diet which had no mention of any sweet foods. The counsel appearing for Tihar jail authorities informed the court that on the whole blood sugar levels were maintained and that Kejriwal was not following the prescribed diet in the food sent from his home. The court inquired if the home-cooked food provided to Kejriwal adhered to the court-approved diet chart, to which Singhvi responded affirmingly, noting minor deviations like sending mangoes thrice and once offering aloo puri as prasad. The court, upon hearing the arguments, reserved its order, which will be pronounced on Monday. In an important update, the Supreme Court bench of CJI D.Y. Chandrachud and Justice J.B. Pardewala assembled today for an urgent hearing to decide a petition filed by the mother of a 14-year-old minor seeking termination of 28-week pregnancy caused by sexual assault. She has approached the Supreme Court against the Bombay High Court, which declined to grant the relief of termination. The minor was allegedly subjected to sexual assault. An FIR under the IPC and POCSO Act has been registered in this regard. During the hearing, the court today noted that the medical report relied upon by the High Court failed to evaluate the physical and mental status of the minor victim, specifically in light of the alleged sexual assault. Thus, the bench ordered for medical examination of the victim tomorrow so as to appraise the court of the possible mental and physical impacts on the minor in the event of allowing such a termination. The petition will now be heard Monday morning on priority. The Supreme Court has imposed a cost of 5 lakhs on the state of Telangana with liberty to recover the said cost from erring officials who have facilitated and filed incorrect affidavits in the ongoing proceedings. The case relates to declaration of reserved forest land as private land in favor of private persons by the High Court while exercising its review jurisdiction despite its earlier order where it had given a clear finding that the title over the reserved forest land was not proved by the private person. Reversing the High Court's decision, the bench comprising Justices M.M. Sundaresh and S.V.N. Bhatti observed that the High Court, which is expected to act within the statutory limitation, went beyond and graciously gifted the forest land to a private person who could not prove his title. The court also contradicted State of Telangana's stand on the suit property, where it first took a stand that the suit property is a reserved forest area, but later on changed its position by constituting a committee which held that the land was required to be excluded in favor of the private persons. In the next update, the Supreme Court bench of Justices M.M. Sundaresh and S.V.N. Bhatti today heard Yoga Guru Baba Ramdev's plea to combine several FIRs filed against him in different states over his alleged remarks that allopathy cannot cure COVID. The FIRs were registered in states of Bihar and Chhattisgarh based on complaints by the Indian Medical Association. The complaints allege that Ramdev's comments were likely to cause prejudice to COVID control, as the misinformation spread by him in a position of influence could dissuade people from availing proper treatment against the pandemic. In the writ petition filed now, Ramdev has sought clubbing and consolidation of the FIRs and their transfer to Delhi. As an interim relief, he has also sought a stay on the investigation in the FIRs. Observing that the petition was filed in the year 2021 and the charge sheet would have been filed, the Apex Court today granted 2 weeks' time to the state of Bihar and Chhattisgarh to inform it about the status regarding the FIRs and the charge sheet filed. As you already know, Ramdev is also facing contempt proceedings initiated by the Supreme Court for publishing misleading medical advertisements in breach of an undertaking given by Patanjali Ayurved to the Supreme Court. This matter is being heard by the bench of Justices Hima Kohli and Ehsanuddin Amanullah. A Punjab court has awarded death penalty to a 32-year-old woman for burying her neighbor's 2-year-old daughter alive over jealousy and an inferiority complex with the child's family. The court noted that the convict in this case took the victim from the street across from her house where she was playing. She stuffed sand in the mouth of the child and buried her alive in a pit already dug in a deserted place, without there being any fault of the child or any provocation from her side. The convict had confessed to her family friend that she had buried the deceased child alive in order to frighten her family because she did not like how her father used to bring gifts for his children. Sessions Judge Munish Singhal stated that ordinarily murder is grave by its nature, more so when the perpetrator of the crime is a known person. It is graver and the rarest of rare, which warrants a strong deterrent judicial hand. Further, the court said that indeed such a criminal was a danger to society at large and was beyond reformation and rehabilitation. The manner in which the crime had been committed was so intense that it had shocked the collective conscience of the society in extreme indignation of the community. While observing that the case comes under rarest of the rare category, the court has awarded death penalty. In another update, the Supreme Court today ordered that keys to a mosque in Erandol Taluka of Jalgaon in Maharashtra will remain with the Municipal Council. With this, the bench of Justices Suryakant and K.V. Vishwanathan disposed of an appeal preferred by the Jumma Masjid Trust Committee against the Bombay High Court's order, which had directed it to return the keys of the mosque to the council. In this case, the collector had passed an interim order restraining people from offering prayers at the mosque and directed the Jumma Masjid Trust Committee to hand over the keys of the mosque to the Municipal Council's chief officer. This order was passed on a complaint filed by a Hindu group which claimed that the mosque in question is a temple and accused the local Muslim community of encroachment. The trust approached the High Court against the collector's order. The High Court initially stayed it but eventually dismissed the petition. This order of the High Court was thus challenged before the top court. The top court today ordered that the keys shall remain with the Municipal Council. At the same time, it clarified that the council would depute an official to open the gate well before commencement of namaz in the morning until all the namaz are performed. Furthermore, the court also stated that the masjid compound should be under the control of the Waqf Board or the Masjid Trust Committee till further orders. This is an interim arrangement till the district collector finally disposes of the proceedings. And lastly, the Supreme Court today sought Union government's response on a petition filed to allow an intending couple having a healthy biological child to reproduce a second child through surrogacy if it so wants. The bench of Justices B.V. Nagratna and A.G. Masi passed the order upon hearing a petition which has been moved by a married couple prevented from conceiving the second time in exercise of its right to reproductive choice. The condition under challenge here is that of Surrogacy Regulation Act of 2021, which says the intending couple should not have had any surviving child biologically or through adoption or through surrogacy earlier. There is, however, an exception in favor of the intending couple whose first child is mentally or physically challenged or suffers from life-threatening disorder or fatal illness with no permanent cure. The petitioners claim that the impugned provision is irrational, discriminatory, and without any sound determining principles. They highlight that it excludes from its ambit the cases of married couples suffering from secondary infertility. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.